Well, thanks, John. Thanks, Cameron. Thanks, everybody. This is a treat for me. I'm going to try, in my comments, first to sort of explain why I find John's paper so compelling, and then to suggest why I'm not sure I buy it. And hopefully put some questions to John that will at least encourage him to convince me more thoroughly that I'm wrong, which I probably am. So John told us about what he called the substantive view, or the rights view of habeas. Amanda Tyler has called this the broad view, although I think that's a bit of a misnomer, which has especially been championed in the last 10 years by Justice Scalia, and to a lesser degree by David Shapiro and Amanda Tyler. And it has three hallmarks. Right? The first hallmark is that a suspension of habeas corpus authorizes detention. And so there cannot be damages after the fact. The second is that it is exclusive. Meaning that there is no other basis for detaining without criminal charges. This is exactly why Justice Scalia dissents in Hamdi. And the third is that the suspension clause only applies to those who are entitled to protection. Right? This is Phil Hamburger's most recent contribution, which is why Justice Scalia dissents in Boumediene. Right? Which is to say, non-citizens outside the United States aren't otherwise protected by this beautiful, wonderful, substantive, sweeping protection. The substantive view runs into difficulties, and John's paper, I think, does a fantastic job of articulating some of those difficulties. The Alien Enemy Act has always been, I think, one of the hardest arguments for the Scalia school to grapple with, since it is so contemporaneously close to the founding and presupposes a source of power so incompatible with the substantive view of the suspension clause. But John, I think, still puts himself out there as generally ascribing to the substantive view. And I think what I'd like to do is explain why I'm not so sure that necessarily follows. So for example, right, John suggests that suspensions are still substantive, but that they're not exclusive, right, that the government can detain without criminal charges through any number of respects. It's how he accounts for civil commitment, the Alien Enemy Act, quarantines, I suspect, if it were to come up, bail, immigration detention, etc. But also that I think you almost get there at the end of the paper that the suspension clause doesn't actually protect a remedy at all. Footnote 160 sort of, which I found very fascinating, sort of ducks around this question, and I wonder if you might actually have to take it on a little bit. And in fact, I actually think that your historical critique might lend you more to the dicey remedial side of the equation than you might be comfortable with. So here are 8 specific questions that I have. And I suspect that I'll be brief in framing them so we can get to your questions. But here are the 8 questions I think you should address that are either sort of addressed or not fully addressed in the paper. First, why is the suspension clause in Article 1, Section 9? Right? That is to say, by your reading of what the suspension clause does, it's another grant of power to Congress alongside the power to authorize other forms of detention. If it doesn't do anything else, why not just put it next to all the other powers? I think you have an answer for that, but I think fleshing it out might actually be revealing. Second, if the suspension clause is neither exclusive nor remedy protecting, which is, I think, your unique position as compared to the 2 existing schools, isn't it fairly useless? Right? In other words, couldn't Congress accomplish most of what the suspension clause would allow or prevent it from doing in either scenario through its other powers? And here I'm reminded of how the seditious conspiracy statute has basically mooted the treason clause. Right? Congress could just dress it up as something else. Third, and relatedly, doesn't the debate, both at Philadelphia and in the ratification debates, suggest that the founders saw the suspension clause as a critically important provision, and that your reading moots or at least waters down its significance in a way that seems hard to square with how big of a deal it was both at Philadelphia and afterwards. And Pauline Mayer in her new book has some really cool stuff about this, like at the Massachusetts ratifying convention. Fourth, if the suspension clause doesn't govern the availability of habeas as a remedy, what does? Right, that is to say, is your position that Congress can therefore do with habeas what it pleases, that Congress never had to provide for federal habeas corpus jurisdiction at all? And if not, what is the limiting principle at that point? Fifth, if suspending habeas corpus means, as you and Amanda say it does, the term of art that you are suspending the habeas corpus acts, the body of law in England, what about the common law? Right? I mean, to me, one of the most compelling points of Paul Halliday's book is that the more vibrant, more powerful habeas corpus remedy in England in the 17th and 18th centuries was the common law writ, not the statutory one. And so, you know, the focus on the statutes to me sort of leaves aside and doesn't fully account for the vibrancy of the common law writ, both during, well, before and after the Habeas Corpus Act of 1679. Sixth, doesn't Halliday's book, which you and I think both adore, provide fairly compelling evidence that habeas in pre-1777 England really had become about judicial power more than and above rights? That is to say that the courts weren't so concerned with the merits, they were concerned with their power to hear every case under the sun. And that varies from tenure to tenure, but especially, say, during Mansfield's tenure as Lord Chief Justice, which coincides with the founding, that was particularly true. I'm almost done. Seventh, in your paper, you are quite skeptical that the remedial view, which you are resisting and which I'm trying to lure you toward, might compel state courts to provide remedies. And it strikes me that your skepticism is troubling. Right? So first of all, the suspension clause was debated at the Philadelphia Convention after the Madisonian Compromise had been agreed to. Right, so that is to say, with full knowledge that there might not be lower federal courts. You cite Todd Pettis' work for the proposition that in the antebellum era, state courts heard federal habeas petitions all the time. Why would it be such a difficult conclusion that that might actually be compelled by the Constitution? Hasn't the Supreme Court said the same thing, for example, for tax refund actions? You know, habeas seems an even easier case. And eighth, and perhaps sort of most nihilistically, doesn't this whole debate actually indict originalism, period, or at the very least as applied to the suspension clause? And what I mean by that is Halliday's historical evidence seems pretty powerful. I read it one way, you read it another. We're not fighting over what the history was, we're fighting over what it meant as applied to terms of art over which there's very little clear debate, right, where we can't look at a dictionary from 1787. Isn't the whole purpose of the suspension clause debate over the last 10 years really to show that there isn't a clear understanding of habeas other than that it was necessarily evolving? And that, as Paul Freund famously said, it was emblematic of protean dynamism. And so I'll sort of leave with my favorite Freund quote. This is in a brief he wrote in 1952, that we'll have to look to history for the essentials of the great writ, but not to one point in that history for its accidents. Isn't the suspension clause a uniquely weak case for originalism? Thanks.